All right, in our last class, we got up through the section of the reading that dealt with the formalities of a will, and we ended on publication. Today, I want to talk a little bit about holographic wills. So far, we've talked about formalities, and the things that have to be done all presume that there's a piece of paper in front of you that you're signing that has been also prepared with some formality, typed, neatly written, organized, orderly. And that's not always the way it's done. And a lot of people think they can just write out their will. A lot of people think once they meet with a lawyer and tell them what they want, then the will is done. They'll tell me after we meet, so we're good, and I say, no, we've just started the process. We've talked about your will. Now I need to get it drafted. I need you to review it. I need to revise based on your review. Then you need to sign with secretaries and a notary and witnesses and a notary and that sort of thing. So no, we're not quite there yet. But holographic wills are kind of a shortcut to a formality. And what it essentially means is is a will in the handwriting of the testator and signed by the testator. Um, and because a lot can go wrong, you know, it, writing a good will that takes into account all the things that can go wrong is a skill. And so when you short circuit that, a lot can go wrong when you allow anyone to write their will. It seems like it should be a right. I get the right to write my will, but we shouldn't trust everybody to be able to write a legal document. So that's why you're in law school. So a holographic will is a will written by the testator in their own handwriting and usually signed and dated. Uh, because a lot can go wrong and because it shortcuts all the formality issues, not all states allow it. The UPC does have a section on it. 502, you might remember 502 is the main section on what are the formalities of a will, how many witnesses, notary, that sort of thing. If you don't meet those requirements in subsection A, then subsection B says a will that does not comply with this subsection in A is a valid holographic will. So the UPC will recognize holographic wills. Not many states do. Alabama does not. But for states that do, what are the issues with a holographic will? The Melton case, page 84, kind of talks through all the ways it can go wrong. This is kind of an interesting case, as cases go. It was a guy who had he had a 1975 will that left, and it was signed by three witnesses and signed by himself. Um, Devised most of his estate to his parents. Remember that his parents, small portion to his brother and two of his cousins. He also indicated that his daughter was to get nothing. In 1979, he had a handwritten codicil on the back of one of the 1975 will forms. Not a good place for a codicil. That a woman, Miss Kelleher, was going to get a small portion of his estate. And those two documents together are called the 1975 will. The will and the codicil are together collectively referred to as a 75 will. In 1995, he wrote a letter to Kelleher, the woman he kind of introduced into the codicil via the codicil. So 20 years later, well, really 16 years later after the codicil to the 1975 will, he writes a letter to her, says, hey, I'm on my way home from mom's funeral. So he's kind of in this reflection mode probably. Um, and he says, I want to leave something to you. I want you to get my entire estate. So Miss Kelleher is now getting the entire estate. I do not want any of my relatives to have one penny. I plan on making a better document than this later. And he tells her the time and he signs it, that kind of stuff. Um, Miss Kelleher, who was supposed to get everything, died before him, and that's part of the big problem here. She died in '02, and then he died in '08. Um, so so if the holographic will from 1995, if it revoked the previous 75 will and codicil, and our only beneficiary in the 1995 will is no longer here, arguably the property escheats goes to the state because there is no taker. So we've really got three views on what happens when this guy dies. His only daughter is still alive, and her argument is interesting. Page 86. She says that the um, She initially argued the 1995 letter is not a will, and therefore she should get the estate under intestate succession. Um, that was before she knew about the 1975 will. So she argues, hey, the 1995 will is not the 1995 letter is not a will. We are clearly under intestacy. I'm the daughter. I get to take everything. Remember, she's the daughter he specifically excluded twice. Um, when the 1975 will was found, she said, well, hold on a second. Because if she argues the 1995 will is not valid, then the 1975 will probably is, and she didn't get anything into that one either. So she later says, hey, wait a minute. Um, she then argued that the 1995 letter is a valid will and it revoked the 1975 will. She argued that although the 1995 letter is a will, it was ineffective because it only named Kelleher, and therefore she gets intestacy and that route because the will's only beneficiary is deceased, and she's favoring intestacy over a sheeting to the state. The second view was apparently this guy had two half sisters, and they argued that the 1995 letter is not a will, therefore the 75 will is, and let's see, they were not named in the 75 will. Oh, but they're going to take the 75 will named his parents. And because his half siblings are children of one of the parents, they're saying they take through them by representation effectively. And then the third view was the state saying, nope, the 1995 letter is a will and the beneficiary is not here. Therefore, all the property escheats to the state and we get it. And we'll put it to good use. So the court goes through all its analysis, and at the end of the day, they say they do point out the law disfavors a sheeting to the state, which is true. The law disfavors any kind of result where the will has no effect and the state gets the property. Um, but that's what happened. They say there was a 95. The proper distribution of his estate under the 1995 letter is an escheat to the state. So they recognize the 95 letter as a will. There's no beneficiary, and it escheats to the state. It's a kind of an interesting analysis if you read through it. And effectively, what you really take from this whole discussion on holographic wills is a couple things. They're out there. They're allowed in some places. The UPC recognizes them, but it's rare that a state rare might be an overstatement. It's a minority view that a state recognizes them. And there's three different types of holographic wills that have kind of developed over time. Page 83. There's the first generation that the entire will, including all of its operative provisions, must be in the testator's handwriting. The second generation is that um, the signature and material provisions have got to be in the handwriting. Material provisions being words like "I leave my house" to my spouse, be in the handwriting. So all the boilerplate stuff can be printed, kind of like a form where you fill in the blanks in your own handwriting. And then the third generation is they only require that the signature and material portions versus provisions be in the testator's handwriting. And examples of material portions are words that identify the property and the devisee. They give you an example. Words of gifting, such as "I give" or "I devise," don't have to be in the testator's handwriting. They do for the second generation. They don't for the third generation of holographic wills. That's just a recognition of, hey, we're going more to a boilerplate form with a few blanks, and you just got to fill those in. That's still a holographic will, but that's kind of a third generation holographic will. All right. So what constitutes the will? What makes up the document or documents as the final will? Page 89. There's this concept of integration. We want to make sure we've integrated all of the right pages to be in what is known as the final document. Did it exist at the time we were doing this will? Is it page numbered? Is it signed? Is it meant to be in this stack of papers that make up the will? That's kind of our first level of doctrines that kind of make up the will. We have integrated everything that was clearly meant to be there, and it was there, and it is part of the will. Are there things that can happen that can change what's in the will, or change the wording of the will? Acts of independent significance. Sometimes there are events that can happen that change the wording or the meaning of the will. Page 9, middle of page 90. And so this doctrine of acts or events of independent significance allows the distribution of the will to be affected by a couple things. Any fact, act, or event existing or occurring outside of the four corners of the document, so long as it is an otherwise objective event that occurs without regard to the testator's plan of disposition. So it's kind of like an event that, um, just what it says, has enough independent significance, i.e., it's very objective, wasn't intended, wasn't influenced, wasn't subjective. It's an objective event that kind of affects the flow of the assets, but it's objective enough to be allowed. Um, and let's see. Oh, the example they give is I leave the residue of property to the residuary beneficiaries identified in my mother's will. Um, let's see. Or purchasing a new car or house. I leave the house to my son. Well, when you draft the will, you've got a certain house, but that house may go away and you may acquire another house later. That's changed the devise of the property, but that's okay. Same thing can happen with cars. Adding afterborn children. It's super common to have afterborn kid clauses in wills. I leave my wills to my kids that I have now, and any children hereafter born to or adopted by me. More people are coming in to get it if I happen to have a kid, and that's a somewhat objective event. Um, the book goes on to clearly say, top of page 91, some events are too closely linked to the testator's actions to qualify as events of independent significance and may invite will contest. Um, that might be a clause that says, I leave the property in the drawer, um, next to my bed. Can somebody go switch the nightstands? Can they pull a drawer closer or further away from your bed to change what property they're talking about? Maybe, probably. That would be too loose. I might say it's too loose of a description. All right, so that's the second doctrine. Third one, page 91, is including additional. Well, this isn't really a doctrine, but including additional non-attested documents. Well, it is. They call it the doctrine of incorporation by reference. Um, this comes up. Well, let me just say this. You go through a lot of these formalities to have a will. It's printed, it's there. You maybe sign every page, you maybe initial every page. You have two witnesses that watch you sign those pages. A notary watch you and the witnesses to make it self-proved. So can you really bring in other pages later? Should you be able to do that? Well, maybe. Sometimes they're, if you leave your jewelry to one person or your gun collection to a favorite child, and then you have a grandkid later, and that's who you want to get it, do you really have to get everybody back together to have two witnesses and a notary, pay the lawyer to revise the will? Maybe not. Maybe there's a dose of real life in this particular doctrine. Um, Three requirements for a writing to be incorporated by reference. It must exist at the time the will is executed. The doctrine must be sufficiently described so it can be readily identified. That's pretty easy. Three, the language of the will must show the intent to incorporate a separate document. So the will has got to have some kind of instruction saying, hey, go look at this other document and make it part of my will. And it's got to be in existence and easily identified. Go look at this document titled so and so, dated so and so, because you know when it's dated if it has to exist before you sign the will. So you can identify it pretty easily, and you leave some instruction in the will that you want it incorporated as part of the will. Both the bottom of the page 91. Most states accept the doctrine of incorporation by reference, but not all do, but most do. And it's limit and the doctrine is limited to documents that are in existence at the time of the will's execution, which means you can't make subsequent changes without to that separate document without observing the will's execution formalities. Sometimes. Um, the UPC in some states recognize an exception to this doctrine, allowing for the inclusion of a subsequent, that's important, of a subsequent or subsequently modified document under certain limited conditions. So, what we're really saying there is you have your will, you incorporated a document that says who's going to get the gun collection or who's going to get the jewelry, but it exists at the time you sign the will. You just haven't put it in the will. You're saying, go look at that other document dated March 5th, 2019, and it's going to list the people I want to get my gun collection or my jewelry collection. Um, and and you can do that. You can go one step further and you can amend that separate document after you've signed the will um, under first full paragraph on 92. An unattested memo or list, like I just described, a list who gets the gun collection, a list who gets the jewelry. An unattested list is permitted to supplement the will, even if created or amended after the will, if the testator explicitly refers to the separate document in the will. So you got to have some language in the will saying, I may do this list, and I may change it later. You got to have some kind of acknowledgement that this was going to possibly happen. Um, the separate document disposes only of tangible property. So only tangible personal property, no cash, no real estate, tangible personal property, books, clothing, furniture, jewelry, furnishings, art, those kind of things. Not cash, not stocks, not bonds, not real estate, not the big stuff that I sometimes talk about. Um, and so you can do it under the UPC. You can actually do that here in Alabama as well. Um, Couple things. If there's a conflict between the memo and the list and the will governs. Um, Unless you can specifically say if there's a conflict, I want the memo to govern, but the default will be that the will governs unless you've said otherwise. Um, Unless you have a section like UPC 513, and I'm not worried about the code section, but unless your state has a code section allowing a subsequent modification, then you can't. You're stuck with what existed at the time you signed the will. All right, continuing with what all makes up the will. Book talks about republication by codicil on page 92. So a codicil, you probably know this by now. A codicil is just a fancy name for I don't think fancy is not the right word. It's just a weird word for an amendment to a will. We could have called it an amendment, but we call it a codicil. So a codicil, you have your will, and you might prepare an amendment or a codicil to your will to change. It could be something super simple, changing the executor. It's no longer John Doe, now it's Jane Doe. Super short codicil. It might be something longer. In section 5 of my will, I described 20 people who are going to split $100,000. I'm now revoking that, and I'm replacing it with a new description of 15 people who are going to split the money instead of the 20. It might be a little bit longer. Um, at some point, it's so long that you just rewrite the will and you don't do a codicil/amendment. But anytime you do a codicil, you got to sign it because it's just like the will. You've got to sign it with the witnesses, the formalities, all in accordance with the UPC, your state's version of the UPC. Remember, being the memo of personal property being kind of the only exception. But a codicil, a true amendment to your will, has got to be signed with all the same formalities. And when you do that, you actually you're not revoking the will. You might be revoking a section of the will, but when you sign your codicil, you're republishing the will as modified by the codicil. So you have republished, you've given kind of current new life to the will. And so that could change a couple things about what's going on. Bottom of page 92. Um, under incorporation by reference, if Terry has an April 20, 2017 will that says, I leave my jewelry to the persons identified on a typed list dated January 15th, 2017 in my blue jewelry box. That's fine. That list was incorporated by reference because it existed when he did the will, and it clearly identifies where it is, and it's you can tell which list he means. Um, at the bottom of the list, what if he adds, I also give my grandfather's gold pocket watch, not the will, but the list. I give my grandfather's gold pocket watch to my nephew, Jason. He signed the addition and dated it May 1, 2017. Well, May 1, 2017 is after the date of the will. And because that addition did not exist at the date of the will, it's not given any effect. Jason won't get the watch, barring some kind of statute that allows you to subsequently amend the memo later. But let's say that doesn't exist. But if Terry later does a codicil to his will, let's say changing the personal representative or executor, and then the codicil is dated July 1, 2017. What your book correctly says is that effectively moves the date of the will forward from April 20, 2017, all the way forward to July 1, 2017, when the codicil signed. So now that date, July 1, 2017, is after the addition to the memo. Therefore, the memo is now inclusive of who gets the jewelry and who gets the watch. The memo exists now as of the date of the will. So formalities are important, and they're kind of picky, and there are ways things could go wrong. Are there ever times the formalities are relaxed? Well, yeah, sometimes. There's a couple doctrines starting on 93. The doctrine of substantial compliance is one of them. And I don't know. This isn't the really good case. Mm-mm. Substantial compliance effectively allows a court to recognize the will if there's some kind of defect there, but there's enough. There's a let's say, what do they call it? A rebuttable, dependent, and on strong evidence of intent and satisfaction of the purpose of the will. There's enough outside evidence for a court to come in and say, "Hey, it was substantially in compliance with the formalities, therefore we're going to recognize it." No, it's there, but that's not what you want to rely on. Another doctrine called harmless error allows a court to otherwise or excuse an otherwise defective execution based on clear and convincing evidence that the defective execution nonetheless fills the goals of formalities. And this one it's recognized by the UPC 503, and it gives you the statute at the bottom of the page. Top of page 97, harmless error does not excuse all defects. The proponent of the defective will must establish by clear and convincing evidence. So you see those words again, really high burden, and it should be really high burden that the decedent intended the document to be the will. And second, the larger the departure from the formalities, the harder it is that you're going to fall within this doctrine of harmless error. I think their book talks about maybe 10 states recognize this error. So formalities are pretty important. I call it low-hanging fruit. They're easy things to meet, so don't take them for granted because they can make the whole document ineffective. But for things like the doctrine of substantial compliance and harmless error, and you don't want to be the lawyer relying on those two things. The McCool case on page 98, read through it, but it talks about a case where a woman, had almost gotten the will signed, had her will revised, had been through with the lawyer what she wanted to say. She just hadn't signed it yet, and it talks through how substantial compliance can come into play there. All right, a couple common provisions in a will. Page 103, the exordium clause or the preamble. It identifies the testator. This is bottom of page 103. Acknowledges the intent that the document be the will, And it usually says you're revoking all prior wills. You'll find that in virtually all wills drafted by a lawyer. Who it is, you'll also find that it'll say, I'm of sound mind and body. I'm revoking all prior wills, and now this is what I mean going forward. Um, and then there's different types of devises. This is important to know too. Bottom of page 104, there's effectively four types. There's a specific devise that refers to a particular item. Um, my car, my jewelry, it's leaving something specific to somebody, specific devise. And if the devise isn't there, it's not there. They don't get that. They don't get that thing. There's a demonstrative devise where you're paying it from a specific source. The example they give is $50,000 from my bank account at DEF Bank. And when you die, there's only 40,000 in the bank account. Then that 40 will go to the devisee, and then the remaining amount can be taken from other assets. Demonstrative says, hey, look to this thing first for this devise, and if you need to pull it from some other places later, you can. But look to this thing first. General is no guidance on where you pull it from. I give $10,000 to each of my children is the example they give. We don't care where you get it from, but those kids need to get $10,000 each. So you got to pull it from somewhere. And then the last type of devise is the residuary devise, sometimes called the leftovers. They're going to get whatever's left, which may be nothing. Once you the other things take priority, and then the residuary is kind of the bottom, whatever's left. All right, let's stop there, and then we will pick up on Wednesday with amendments and revocation of wills. Thanks.